Jeanette got it, so thanks.
She usually does, but
Yeah, good to check. Are you Martina Yvette Brinson?
Yes, sir.
Ms. Brinson, you got charged with a complaint that alleges some felony charges. And the rules are a little different with felonies. There goes my screwy Kramer box. The complaint alleges that May of this year in the city of Three Rivers, which is Walmart, that you were stealing property worth more than $200 and that you have a second or subsequent retail fraud. So they've charged it as a felony retail fraud in the first degree, which is punishable by up to 5 years imprisonment and a fine of up to $10,000, alleging that you had two or more co-defendants. So they charge them with conspiracy. And they're charged with lying to a police officer and as a third habitual offender, which I guess I did start it and it went screwy. I said they were here yesterday and they fixed our Kramer box. Apparently not. It's going haywire. At any rate, the gist of this, Ms. Brinson, is these are felonies. Because it is a felony, I don't have jurisdiction to take your plea. I'm going to appoint a lawyer for you to assist you with this. Is that agreeable to you?
Yes, sir.
Do you still live on Euclid Street?
Yes.
Are you employed?
No.
I'm going to appoint an attorney. I'm going to set a pre-exam conference for June 10th at 8:30. Preliminary examination if it's needed for June 17th at 1 p.m. Let's see what this is all about. Hell, this was a long deal. You and some others. So they charged it as a first offense. First degree. You posted a bond of a $4,000 surety bond. So your bond is in effect. And so you're good to go in that respect. What I'm going to do, I'm going to have the court officer take you out to the counter and the clerks will give you some paperwork with your lawyer's name and number on it. And I want you to call that lawyer and make an appointment to discuss this with them prior to the June 10th date. That's your next date here in court. Have any questions?
No, sir.
All right, you're not to go to any Walmarts in the meantime either. All right, you're good to go. Miranda Mystique McCann. Good morning, Mr. Coleman. I understand as I walked in the door this morning that they're working on an adjournment of your case.
I know they've requested it.
Yes.
Our counsel's still coming.
Yeah, he was trying to reach him. So anyway, I'll be here. We'll see how this plays out.
Thank you, John.
You Martina or Miranda Mystique McCann?
Yes, I am.
Well, let's take a look at your case. You got a traffic ticket, which is a lot different than the last case that was a felony. You got a ticket for driving without a valid operator's license. We get lots of those. Let's see how this is charged. No ops 257-301 in the city of Sturgis and expired plates. Expired plates is a civil infraction, carries a $120 fine. Mr. George, the city attorney, has offered to dismiss that case and dismiss the no operators if you plead to an offense called allowing another to violate the motor vehicle code. So let's talk about that. It's a misdemeanor, no operator's license. Sometimes we call it no ops, 257.301 in the motor vehicle code. It's punishable by up to 90 days in jail, a fine of up to $100, and it carries 2 points and it goes on your driving record. So it'll make it harder for you to try to get your license. It'll delay it. Mr. George has offered to dismiss both of these charges if you plead to a misdemeanor charge of allowing another to violate the motor vehicle code. It is a misdemeanor, but a relatively very minor one. It's punishable by up to 90 days in jail and a fine of up to $100. Now, rarely does anybody go to jail for this. The important part is it carries no points. It doesn't get abstracted to your driver's license. It won't affect your ability to try to get your license. Do you understand?
Yes.
Other than that, did anyone threaten you to get you to plead to this
No.
or promise you anything?
Nope.
And you understand by pleading to this charge, you'll be giving up all the rights that were on that sheet regarding your advice of rights that you signed. You
Yes.
understand? All right, where were you going on May 7th?
I was actually headed home. When I got pulled over right in front of my house.
You're driving a pink Cadillac?
You said pink?
Yes.
No, it was white.
Oh, okay. A white Cadillac,
Yes.
coffee colored Cadillac. All right, and you don't have a valid license?
I do now, actually.
Oh, very good.
I have the paper of
All right,
completion.
that's why Mr. George did this. That's really all we want. If you got this no ops, that would undo what you just did. So Mr. George is dismissing it. So you have a valid Michigan license?
Yes. It'll be.
Did you ever have one before?
No.
How old are you?
29.
Well, what happened is this made you do what you needed to do.
Correct.
And so that's really all we want. You would have probably just cruised along till something else bad happened until you got your license. So you had to take your driver's test and all that stuff?
Yep. Last week I did.
Very good. What do you do?
I work at Jayco in
I
Middlebury.
guess I was gonna guess that. Mr. Whipple, good morning to you, sir.
Morning, sir.
All right. I'm gonna reduce the fine a little bit because you actually did get your license. Very good. I'll make it 75 rather than 100. $75 crime victims' rights fee and a $50 state minimum fee. Cost you $200 to make you go get your license. Can you pay that today or do you need some time to pay it?
What's the final cost?
$200.
I could pay half of it today.
All right, well, all right, I'll just give you 30 days to pay the whole thing. $200 due by June 30th. And you can pay half right now, so you can pay with green cash,
Thank you.
certified check or money order, or pay by credit card. So do you think you'll pay half today or just wait and do it all at once?
I can do half today. That's
All right,
fine.
well, I'll have the court officer take you out. You can pay half today. And good luck and congratulations on getting your driver's license.
Thank you.
All we really wanted in the first place. All right, we're cruising along. Todd Whipple. Good morning, sir.
Hello.
I saw this. I saw your name come through. And I felt bad. And when I saw what they charged you with, I felt even worse. Are you Todd Allen Whipple?
Yes, sir, I am.
How you doing, Mr. Whipple?
I'm doing good.
You still live over in Colon?
Yep, I'm still there. I'm still the same job.
Same job?
Yeah.
All right, good. Well, the last thing you need in your life is
Yeah.
methamphetamine.
Yes, sir. You're right.
Gee whiz. So they charge you with possession of methamphetamine, which is a felony. Because it is a felony, I don't have jurisdiction to take your plea. They also charge you with driving with a suspended license. I don't remember when we left each other, whether you had your license or did you
No,
ever get it back?
You were gonna get it for me. I just couldn't keep it going. That's why I didn't get it.
Did you get it interlock and then lose it, or we just
Nope.
never got
I
over the
just-
hump?
Never got it at all.
All right, I guess that's what I remember.
Yeah.
Anyway, you didn't drive here today, so
No,
that's a plus. And you're still at the same shop, so I consider that a success to some degree. Are you missing work right now?
No. I'm working 3 to 11.
Hmm. Well, I'm gonna show a plea of not guilty for you, Mr. Whipple. I'm gonna appoint an attorney
Thank you.
and set a pre-exam for June 10 at 8:30. That's your next court date, and a preliminary examination if needed for June 17 at 1. So don't get any more trouble till we sort this out.
No.
Don't drive anymore till we sort this out. Who brought you here today?
My boy did.
All right, good.
Yeah.
All right, well, we'll work this out. We're gonna get a lawyer to help you with it. Don't step on any more landmines till we see where we're going with this. It's good to see you, but I'm sorry to see you like
Yeah,
this.
sir. I'm sorry too.
All right, you're good to go.
Thank you.
Jennifer Albor?
Hello, good morning.
Good morning. Are you Jennifer Perez Albor?
Yes, sir.
This one is a little tricky, but if I understand it, the prosecutor is charged with resisting and obstructing a police officer. Ms. Davis, the prosecutor, worked on this for a while. But the allegation is that on May 16th, that you did oppose, resist, obstruct, endanger, or otherwise resist Officer Adam Kreitz with the Sturgis Police Department. That is a felony. It's punishable by up to 2 years in prison and a fine of up to $2,000. Because it is a felony, I don't have jurisdiction to take your plea. At least at this level. There is an indication that Ms. Davis may be offering a misdemeanor charge from the email that I saw in the file. Good morning.
Morning.
But that's yet to be determined. Ms. Albor, what do you do? Where are you employed?
I stay at home mom.
Okay. I was gonna ask if you're missing work, but you're missing work if you're a stay-at-home mom.
I have 4 children at home.
All right. Somebody's in it. Darn it. All right, someone else is looking at your file. Anyway, I'm gonna show that you plead not guilty. Don't really know very much about what this is about. I thought maybe some other people were charged with the same thing, but I'm not quite clear on that yet. Appoint an attorney. Set a pre-exam conference for June 10th. We're gonna be busy on June 10th. At 8:30 and a preliminary examination if needed for June 17th. That's at 1. When you're charged with a felony, you're entitled to have what's called a preliminary examination where the state has to prove probable cause that a crime was committed and probable cause that you did it. And if that can be established, the matter is then transferred to the circuit court. But before we get to that point, we have what's called a pre-exam conference, see if the case can be resolved. So that will be on June 10th at 8:30. You posted a $5,000 PR bond, and I'm sure you're in compliance with your bond conditions. So don't get in any more trouble till I see you next. The court officer is going to take you out, appoint an attorney for you, and I will see you on June 10th at 8:30.
Got it.
All right, you're good to go.
Thank you.
Well, that's all the customers we have. Do you need to get a rain for anything as long as you're here?
Me?
Yeah.
No, thanks.
Way up, sleeves on, long pants, and it's like all bundled up, and I'm like, it's 105 with the heat index. And you're walking down the floor with the heat like that, it's like, I go.
Let me just tell you, a guy got a guy was, I want to say he was a little bit upset with me. I'm driving on the freeway. And you know where you're about to get off the freeway,
Like the exit ramp.
the access, right?
Yeah.
But he's not on the access. He's on the freeway hitchhiking. And when he sees me, driving past, he's like, because he's up there hitchhiking. I'm like, what planet are you all living on?
Where I can't, that's when you need the patrol officer to drive by, and you wonder what, when the cases come in, like, well, why did you approach them? It's like, well, you're walking the highway.
Well, I told somebody if I would have picked up that hitchhiker, my Lifetime movie would have been because she stopped.
Yeah,
The Stephanie Boyd story. Oh, yeah.
I don't understand how people still do that.
Yes. Hello.
Hi, good morning.
Good morning.
All right, we're back on Felipe Hernandez. I think I just request that we go on the record on a few matters.
All right. Have you conferred with the state on your motion?
I have.
All right. Have him come down.
I mean, is there really?
You're calling.
I guess you haven't really.
No, we haven't
Okay.
really.
Mhm.
I appreciate it.
So I assume that they're the same.
They're the
text.
same, just with different case numbers.
No problem with this. And
So it kind of seems like we already got this
Yeah.
evidence now since filing of this.
Zero? Is this the only case?
000701 as well, Your Honor.
All right, and 2025 0000701. Could I have parties announce?
Andrew Harris Edelman from the state.
And this is Pauline Portillo along with Ms. Peyton Howe for Mr. Felipe Cerna-Reyes.
All right, you all are scheduled for jury trial today. You filed a motion for continuance?
I did, Your Honor.
All right, and why?
We have several reasons. We do have a motion to inspect and examine evidence, which if granted, I think will require us some time to inspect and examine that physical evidence.
Why wasn't that done before today?
Because, Your Honor, through preparation with my client, which was very limited because of the time frame which we represented him. This was information I had to develop over the course of jail visits, which I couldn't get within 24 hours. And so through prepping with my client, we learned of some evidence that might be, and I would expect strongly would be material and mitigating to the elements in the case. And so that's the reason why it wasn't filed earlier on in our representation of him. But it was filed before the jury trial date of
27.
the 27th, yes.
All right, anything else with regards to your motion? for
I'm sorry,
continuance?
it was filed May 23rd, 2025, and I'll address that motion in a second. But the other issue is, Judge, we had requested missing discovery from the state, and since that request, we've gotten in about 12 videos that are pretty large, and even the state said it's a pretty big file that it took.
What missing discovery?
At this point, it's all been produced, but they are all recordings from SAPD personnel who are at the scene.
Okay,
And they're pretty large videos, Your Honor, and one of them, I think, includes the unmuted portion of the defendant's statements. And I also believe that that's gonna have material and mitigating evidence for his defense. So it's really, really crucial for us to be able to review all.
all
of
right,
the
so
video.
review the video now.
Judge, these videos are an hour and a half. at
Review the
least an hour.
videos now.
Will do, Your Honor. And then the other issue with the motion for continuance is, the other issue with the motion for continuance, Judge, is that to prepare an adequate defense for him and to avoid issues of this case being appealed for ineffective assistance of counsel.
People love to throw around ineffective assistance of counsel. This case has previously been set. He had another attorney. It was set for jury trial, and your firm decided that you were going to represent him and get on a case knowing that it was set for trial. So if you all want to throw your swords on ineffective assistance of counsel and file that with the appellate court, that's completely up to you. Next
Understand
one.
that, Your Honor. The issue is that it is very apparent to me that because there was so much missing discovery that was never requested, that there was not adequate prep work by the prior attorney, and that's why, unfortunately, and I don't want it to be held against him, it's taking us so long to put everything together and figure out the missing pieces.
Oh, no, name the parties who you're saying didn't complete adequate discovery.
Name the parties that
Oh, yeah, who are you
The
talking
state.
about?
the state.
Okay,
So the issue, Judge, is that I don't think that this should be held against him. He's facing substantial jail time. It's an enhanced first degree possession with intent to deliver. And so those cases, they require a lot of links, a lot of connecting the dots. And so my argument for the continuance would be that we definitely need some more time. Just
all right,
because
the
of
video
nature.
is like an hour. What did you say, an hour and what?
So the 12 videos, each one starting at least at about an hour and a half long.
All right, so y'all need to watch the videos today. He's here, you're here, watch the videos.
We'll
Next
do-
point.
Will do, Your Honor, but the other point is that this is a case that has a lot to it. And so it's not just a regular, like a DWI third or another felony that you could get ready for very quickly. And so given the nature of this case and the prep work for it, that is a little bit above and beyond another felony. And this court, that's also the reason for the continuance.
All right, but you all knew that this was set for jury trial, and so you all chose to do it. You've been given your 10 days. So what's your other grounds for a motion for continuance?
That I don't have any other grounds for my motion, Your Honor.
All right, so you all need to look at the, whatever video she says he needs to see, if you will load it up so she can watch the video with her client.
And Judge, I tried to do that when I was here about a week and a half ago, and the state never was able to give me the video because they were too busy, and so
Well, do you see anyone else here now? Load up the video so she can watch it with her client.
Don't you have access to it now?
we requested, but it doesn't come over right away.
So you
It
don't
takes-
have it?
So the other issue, Judge, is we have a motion to inspect and examine physical evidence. The state tells me that they're not opposed to it.
Well, you all should have done that before your 10 days. You had plenty of time to inspect evidence, so.
Okay, is the court going to rule on it?
Oh, yeah, you can expect whatever evidence you want to inspect, but I am not granting a motion for continuance because you all have not inspected evidence that was always available.
Would you like a copy?
They've given me copies of your motion. So state, she wants to inspect evidence. Is there any other motion?
Judge, it's just, there's two motions for each cause number.
Okay,
So I just wanted to see if we could get your signature on both cause numbers.
okay. And other than that, is there any other motion?
Yes, we have a motion to require disclosure of all informers relied upon and for production of said informers.
All right, so what are you basing that? And you're speaking of a confidential informant?
I believe it is, Your Honor.
All right, so there are certain grounds legally where you're allowed to that information. So what are you basing that request
So
on?
Judge, there's a reference to an anonymous tip by the detective in this report. And so I don't know, I think we need to call him in to at least get some testimony about what the anonymous tip was. And generally speaking, like, what's the nature of it? What did it reveal? And is it somebody that this person has worked with in the past? Because that's all I have is that it's an anonymous tip. There's no other
Stay.
information included there.
I can call Ramirez, see if we can get him here.
Okay.
And then we just have we just have other pretrial motions that I
Alright,
expect
sure.
we could argue.
Did you all confer with the state on your pretrial motions?
I haven't. Does the court want to take them up at this time?
Well, I mean, don't you want to confer with the state to see if they're in agreement with your motions? If you don't want to do that, I will hear them. But it would seem it would be economical to see whether or not the state agrees with your motion, then maybe you wouldn't need to have a hearing on it.
Yes, sir.
No, not.
Yes.
Yeah. She says she has motions. Do you have copies of those? The other ones? I only have two. The only one I have is the inspection motions. I don't have the rest. Mhm. Yes. I mean, how long has this been sitting around?
January.
Oh. Like, since January, why am I just not receiving it?
I think, try to follow up on it, so if they never received it. So. I will take it to them.
No, I'm just signing it. I don't, attorneys should get a voucher sign or paid. Yes. Alrighty. You're welcome. Alrighty. All right, while y'all are going over these motions, you need to start watching a video with him, and I'll take your motions up after you finish watching a video.
The prosecutor doesn't agree with the two motions.
All right, so go ahead and watch the video so we can get that out of the way. These motions will only take
Okay.
5 minutes, maybe.
Okay,
All right, thank you.
I'm sorry, am I showing him the video on the prosecutor's laptop or?
However you all do it.
Okay, that's the only way to do it, because we don't have the video.
All right, so this is the thing. If y'all want me, I will step from the bench. I will load up the video so that you can watch it. I don't see that as my job. So you all need to talk to each other. I don't know why it's so hard to talk to each other and get things done. You say you want to see a video, then you're going to watch the video, but this case is going to trial today. We're doing jury selection, and that jury selection, I'm giving y'all this morning to do your videos. That jury selection is happening this afternoon. So either y'all want to get together and look at the videos or you don't, but at 1:30, we're doing jury selection. Okay to witness. So whatever brought you here, you need to change your ways and do better, okay?
Understand.
All right. Good luck to you.
Thank you, Joe.
You're welcome.
Excuse me.
Yes.
Ms. Gann, my understanding is that Mr. Aldridge has filed motions in your divorce case. The final decree was entered on January the 30th of 2025, and he has filed a motion for emergency injunction and expedited hearing on February the 14th. He's also filed a motion to modify vehicle provisions in the marital dissolution agreement. And those were set for today by him by notice. He has contacted the clerk's office and advised that he is unable to be here today and has requested that they be reset. My understanding is that you oppose resetting those motions. Is that correct?
Yes, sir.
And are you not able to, when did you give him a date? July 28th is the date that was given to him that would be available for a resetting.
I don't know. I don't have my phone. I don't have my calendar. I work in EMS. I cannot take off random days that have not been approved for anything. I am also stating that I believe that he is doing this he's doing this just to keep control over what's going on right now. The MDA states he has 90 days to do what he needs to do with the vehicle and set up payment plan or whatever with it in regards to our judgment that was in Clarksville. And however, when I did not agree to an extension, which in the NDA, it states that I have to agree to give him an extension. That is when he started attacking me verbally, saying that I have multiple text messages and multiple missed calls telling me that, I'm gonna take you back to court because this is unfair, blah, blah, blah. When he had, from the time of the MDA, of the finalization of the MDA, 90 days to get the car refinanced in his own name, or he had to turn it back over to me. Well, he has not made any good faith efforts into doing that. And I've been in contact with the loan company and he's been making the payments. However, he has not made any efforts to.
Well, let me interrupt you, and I apologize. I understand what you're saying, and I understand that his motions are to try to modify an agreed order, a marital dissolution agreement that he agreed to. And I understand why that's frustrating for you. They are his motions, and because he contacted the clerk to advise he couldn't be here today.
But he contacted the clerk, and like not even an hour before court started.
So if I could finish, because he contacted the clerk to let them know that he was not able to be here, I don't know the reasons why. I don't know if it's a legitimate reason or not. What we would normally do would then be to find out when you were available, and I will set this motion for a show cause as to whether or not these motions should be dismissed summarily. If, and put the burden on him to appear and argue the motion so that you can get this done. So do you know when you would be available again?
Like I said, I don't have my phone for my calendar. The only reason that I was able to be here today is because I work tomorrow, and I work 24/48s. So I don't know.
What about Friday? Are you off? Do you know if you're off Friday?
I am off on Friday. I get off work that morning.
All right, then just plan to be here Friday morning, and we have Dixon Chancery some matters that we'll put these motions on Friday, and if he's not
Are
here.
we talking about this Friday?
Coming Friday, day after tomorrow.
Okay.
If he's not here, then I will dismiss the motions because he can't file motions to delay the enforcement of a marital dissolution agreement and then not appear and then have months go by and defeat the operation of the marital dissolution agreement. So we'll let him know that he's got to be here on Friday or else his motions will be dismissed.
Thank you, sir.
All right, 9 o'clock.
9 a.m. Yes,
Thank
sir.
you.
Thank you.
Good morning, Judge.
Good morning.
Judge, I'm the court-appointed administrator of this estate. We were in court a couple of weeks ago in the motion regarding Kathy
Well,
Rundle.
let me first address this issue. I've got a motion to continue the motion for instructions that's been filed by Mr. Vandervoort, and he represents Mr. Sam Myatt. So he's filed a motion asking to continue Mr. Reagan is here, I assume, in his stead. So before we take up your motion for instruction, I need to hear whether or not there's a basis for the motion to continue.
I am, Judge. So Mr. Vandervoort represents Mr. Sam Myatt, who's one of the heirs. Mr.
Trust me
Vandervoort.
when I tell you, I know all about this.
You
case,
understand, Judge, yes. So he's out of town today and will be for several days and could not be here. That was one of the bases for asking for the continuance of this. The second reason is, Judge, I don't think this case is in a position yet for this motion to even be granted. And I know that's a separate issue and Your Honor will take it up after deciding this, but there is still the DNA testing that is going on. And so for that reason, even in arguing the motion that Mr. Odle has filed, we're going to suggest that it should be continued.
Is there some urgency about the motion for instruction that would require that to be taken up?
Well, Judge, I've been contacted by several heirs about personal property at my office. And then we were in court a couple of weeks ago. Your Honor instructed me to file this motion, and I did so. I understand what Mr. Reagan is telling me.
Well, I'm a firm believer that if a lawyer is involved in a case and he is out of the state on vacation or whatever, that it should not be taken up in his stead. So for that reason, I'm going to grant his motion to continue until Mr. Vandervoort is actually present and able to deal with this situation. So my thought would be, we just need to find out when he's going to be back and when the opportunity would be present for us to have this hearing. I agree, the errors that are involved in the case have, one of them appeared before me and was arguing, not arguing, but I mean, was pointing out the fact that it's been 2 years and there were personal items that, you know, could be distributed. So when is Mr. Vandervoort going to be back?
Judge, it should be, it's going to be a couple of weeks.
I'm sorry, what?
Ms. Roberts knows better than I do. Yes.
And Judge, just, this is not really relevant to the motion to continue, but Mr. Knowles contacted me this morning and said that Ms. Rundle doesn't take a position relative to the manner of distribution, that she would want copies of photographs. And Mr. Knowles asked me to make that announcement, and he called me this morning.
We have the Bates versus Bates custody hearing on the 16th of June, correct, Ms. Roberts? Well, is there any reason we couldn't have this hearing on this motion on the 16th in the morning then? It shouldn't take long, should it? This motion for instruction?
I think you're only just gonna have to say.
Well, it would be nice if everybody could come to an agreement, since they obviously in this case can't agree on it, things. It may be that I'm going to have to do something arbitrary, and you know, that may be what I may very well do is order that there be a private auction where everybody just shows up and they all bid on whatever items they want, and you know, if they bid on it, if it's just $1, but if they want it and they bid $1 or they bid $100, that may be the simplest way to do it. So. We will set this for 9 a.m. I'll tell you what, yeah, it's, I would say 8:30, but it's Monday morning. So let's do 9 o'clock on the 16th day of June. And we will do the, we'll hear your motion for instructions. And, you know, you might explain to the parties, all of the parties involved, what where I'm heading, you know, because if they think I'm going to go over there and look at everything and make a decision on who gets what, they're wrong. I'm going to do something like akin to what I've just said, and that is argue that we're going to order that there be a private auction conducted by Mr. Odle in which everybody that's interested shows up and they bid on each item of property, and, you know, whoever bids the highest gets it. The money goes into a pot and it'll be distributed along with everything else. It just seems to me to be the simplest thing to solve the problem. So if you can explain to them that somebody's going to have to convince me that's not the right thing to do, and if they can, you know, if they want to convince me, then they need to be here 16th of June at 9 a.m. If everybody agrees that that's a logical way to handle it, then you can just do an order for that and won't have to be here on the 16th and save everybody's attorney's fees in showing up. So I'm trying to give you a pathway to get this done without having to come back to court, but we'll see.
Judge, if we had to argue that today, that was going to be our client's request.
Well, it seems to me that if that was going to be your client's request, if you're going to have to argue it, and I'm just going to do this. I'm just going to arbitrarily say this is what's going to happen. It's pointless for you to keep coming back to court over these matters when there's a simple solution that can be done. I'm ordering that Mr. Odle will conduct a private sale and it will be set far enough away to adequately provide notice to everyone that's involved. Every heir that's an heir has the right to be there. And they will all have the right to bid. Mr. Odell you still have your auctioneer's license? Mr. Odell will conduct the auction, and by that, I mean, each item will be bid upon separately, and whoever, has the highest bid will do it. They will pay for the item that day in a verified manner. In other words, we don't accept IOUs. We don't have a promise to pay or anything. We're just gonna say, you show up, you could be ready to pay by cash or check, and it has to be a valid check, but we'll go from there. Ms. Roberts, are you gonna throw a stone in the middle of what I'm trying to do?
Make sure that that's what I was requesting, that all of these people are entitled to a disbursement. I just wanted to make sure that it wasn't a situation. Now, I'll gladly pay you Tuesday for it. I can just stay. So just take my bid out of the money.
No, everybody pays, there's no deductions. Everybody that bids on this item pays for that item that day. The distribution will be made subsequently, and once we determine who all of the valid heirs are, which is yet to be determined because we're waiting on DNA results. So, we have somebody in the back that's raising a hand. So if you want to speak, come up. What is your name, please?
Sheila Woodard.
All right.
My question is, will it be just like a bid? I mean, if somebody bids $2 and then $5, it'll just keep going up until, when will it close?
That's right. That's what an auction is about.
Yeah, but, so it'll close that day?
Yes.
Okay.
Whoever, we're not gonna, this is gonna be, whenever Mr. Odell sets it, it will be a very simple matter. If this mouse was one of the items, Mr. Odell will say, this mouse is the item up for bid. How much am I bid for it? Somebody will bid $1, somebody will bid $2, and when the bidding is done, whoever has the highest bid will get that item, but they have to pay for it that day. And Mr. Odell will keep a record of this person, Sam Myatt, bought this mouse for $25, and he'll have that down. At the end of the day, Mr. Odell will total up how much Mr. Sam Myatt bought, how much you bought, how much everybody bought of those items, and he will have to have a check for those items, or paid in cash preferably, and he will deposit that into the account, and there will be a recording of each item that's sold, and everybody will have a record so that everybody knows that nobody's getting hoodooed. So I don't know of any other way to do it to try to give you all a chance.
I agree, right.
In an ideal world, you all could get together and civilly disperse these things so that if there's a particular item that you wanted, you could have a particular item somebody else wanted. And that's the way it would be done. But we're in the middle of a lawsuit that the parties are so contentious that we can't agree on anything. So we're going to do it this way.
That's fine.
Okay?
All right, thank you.
All right.
Ask one question.
I don't know if I want to let you ask.
There are a number of photographs and which could be duplicated, and certain heirs have brought that up to me as a possibility.
Anybody that wants the photographs duplicated, I don't know how we're going to go about doing that. So, how many pictures are there?
It's quite a few, Judge.
100?
Surprising. There's a lot. Some frames, multiple photos, and some were just found.
And Judge, it's our suspicion that if they took them out of the house, and if they're in a frame, if there's a box of pictures, you sell it off. Not a majority sell a picture.
All right. Any framed photographs will be sold individual. Boxes of photographs will be sold as a box. If you want to break it down into collections, that's fine. I mean, you can do if there's a box that's got 50 photographs in it, you want to do 10 of it, gather them in groups of 10. Anyone who buys the photographs can be contacted by the other heirs who can hopefully have a good enough relationship that they will then agree to let them copy those photographs. I mean, that's what family's supposed to be about. So, I mean, I say that not necessarily for you, but I say it for hopefully some of the people who are involved in the thing. Work together to try to give everybody a copy of the photograph that wants it, but we're going to dispose of those photographs. So framed photographs will go as individual items. But, you know, other loose photographs will be gathered, depending on what, I mean, if you got 200 photographs, gather them in 25s, and you got 4 groups of, or 8 groups of 25 photographs, however they're lumped together, and let people bid on them. And then hopefully they'll all get together and look at them, and they'll say, well, can I have a copy of this one or that one? And maybe they'll all go to lunch together and discuss it and maybe get over some of this animosity. So.
Judge, I really don't know the number of photos. I just know that there's a number.
Back porch.
It's available.
How are we gonna cut, again, we all do this.
When can you do it? All right, let's just talk. We're gonna settle this matter right now. When are you available to conduct this? How much lead time do you need? Obviously, Mr. Vanderboort wants to be here, so after the 9th of June, but when, after the 9th of June, are you available?
I would say anytime a month. It's fine.
Ms. Roberts, are you gonna be here for this auction? How much stuff is it going to be? I mean, it's all in your office, so surely you want to conduct it at your office? You want to do it here at the Justice Center?
Judge, it would be easier to do it at my office.
All right, then we'll do it at your office. All right, your office. Now give me a date. Good idea. I'm in Humphreys County on criminal trial, so I'll be out of the area. Yeah. All right, June 20th. What time do you want to conduct the auction, Mr. Odle?
I don't have anything on the calendar.
2 o'clock? Two o'clock on June 20th. All right.
I don't expect him appearing. We haven't been able to contact him. A few years, we believe he's homeless. And I do have one witness.
So are you ready to proceed?
I'm ready.
All right, bring up your client.
Ms. Dodson, do we need to bring up the witness or swear him later?
You have a witness, Ms. Dotson, come on up. All right, this shows he was delivered a copy of the summons on the 20th day of December.
Yes, sir.
This is from 2021?
Yes, sir.
And you served a copy of the motion, the notice setting a motion for default on the, all right. All right, all those who are going to testify, raise your right hand. Let's place you under oath. All right, put on your proof.
Ms. Dodson, will you state your full name, please?
Laurel Ann Dotson.
Okay, and you presented with my office certain statistical information that was incorporated into the complaint. Still true and correct. Information, knowledge, and belief.
Sir.
Okay, and you allege inappropriate marital conduct in the divorce. Could you describe to this his honor what creates the grounds for inappropriate marital conduct? If you just go back over the last 6 to 8 months of the relationship.
Just quit coming home, starting out on drugs, in and out of jail, and then I didn't see him again.
And The divorce complaint says that you all separated in 2015. So, is that true?
Yes.
And over the last, before he was served, when was the last time you saw or heard from Mr. Dotson?
5 years ago, he stopped by to try to take Allie, our daughter, to go spend the night with him, and she didn't want to go, and I haven't seen him since.
Okay, and has he left you without helping you in paying bills or rearing the children or anything?
I haven't seen or heard from him. I've got nothing.
Okay, now, do you all have two minor children left?
I have one,
One minor child left, and what's her name?
Aaliyah Dotson.
And how old is she?
She is 13. What's her date of birth? 6/20/11.
Okay, and you had signed and notarized a proposed parenting plan that's been filed with this court. Would you like to adopt that?
Yes.
Okay, and you had, you're not aware if he's worked or anything or has a job or any income?
The only thing I know is he's in the homeless camps. I don't know of any employment.
Okay, and you've also tried to find him in that homeless camp and couldn't find him there.
I've tried through his sister, who also hangs out in that area, and I
And what
No
was
luck.
what was your gross yearly income for 2020?
around 21,000.
Okay, all right, so around 21,000, and he probably makes zero, so I guess, Your Honor, we input his income to $1,256.66.
You would impute it according to minimum wage, is that what
Yes.
you're saying? All right.
Okay. Now, in the proposed permanent parenting plan, you have 365 days to his zero, and that you're proposing that if he wants parenting time or if he comes back around, he's gonna have to file an appropriate petition with the court. Now, there's also another issue. Did you have a child during the marriage? Okay, and who was the father of that child?
Jan Darwin Black.
And do you know where he lives now?
I do.
Have you been searching to find him since the child was born? Has it been difficult to?
Is the child that you're talking about not one that's on the parenting plan?
He's not one on the parenting plan, Your Honor, and we are filing a petition because we think we know where he is in Stewart County to have him served with that. So Mr. Dotson can be disestablished as the father.
Well, you've alleged in your complaint there are two children born. One's now an adult, one is 14. Is that
Yes,
correct?
and then now there's a 4-year-old boy that's not Mr. Dotson's.
Well, that child is not a part of, you don't allege that,
No, I
even
don't.
the existence of that child. So there's no reason to go into that. You're going to have to deal with that in a separate proceeding.
We're going to do that in juvenile court in Stewart County. All right. Now, is there any furniture, furnishings, personal belongings, or anything that he has of yours, or you have of his? Y'all have same bank accounts, anything? Y'all have anything together?
No.
Okay. Not even a Ford? All right, Your Honor. I would ask the witness.
I don't have any questions. You want to put on your other proof?
Okay. Sir, what's your name? And how long have you known Ms. Dotson?
Last 3.5 years.
Okay.
My ex-wife takes care of it.
Okay. And did you listen to her testimony? Does it seem like that was fairly, you cooperate with some of that stuff? What do you mean by that?
She works herself, she cleans my house, she works at a farm of a good friend of mine, Ms. Chambers, it's a sanctuary. She works at the popcorn place, she works herself to death.
And do you know of Mr. Dotson being around?
Never seen him.
Never seen him?
Never.
She's been left having to rear the children herself?
All right. Ms. Dotson will be awarded an absolute divorce on the grounds of inappropriate marital conduct. She's awarded all personal property in her possession. He is ordered to pay any debts that may be incurred in his individual name, and Ms. Dotson will pay any debts in her name. I will adopt her proposed parenting plan designating her as the primary residential parent for the one remaining minor child. Child support will be set based on the income, the proof of the income, which according to what I'm understanding is minimum wage for him and 21,000 a year for her, 0 days for him, 365 days for her. And I assume that is your child covered by a 10 carer?
Yes.
Okay. And there's no insurance issues. She'll continue to be under that.
Do I need to do a whole new parenting plan or?
No, we can use the parenting plan you've got. Well, yeah, you probably should do a new parenting plan because this one's marked as filed as a proposed. This one, you need to put one that's final parenting plan.
I'll do it.
All right.
Thank you, Judge.
Thank you. All next case.
Good morning, Your Honor.
Good
This is
morning.
actually an easy one this morning. This is a motion for judgment by default. This is an action to quiet title. Ms. Ferris, the plaintiff, was married to a Patrick Cale Ham. They were divorced before this court in 1994 on the grounds of irreconcilable differences. Their MDA, which was incorporated into the final decree, provided for their continued co-ownership of certain real property as co-tenants with right of survivorship, but neither the MDA nor the decree gave the kind of specific deed reference that would allow an otherwise ignorant title examiner to confirm exactly which dirt was being talked about. And Ms. Ferris is now enjoying unmarketable title to that property, so that's what we've done. The defendants to this action are, of course, the known devisees of Mr. Cam, as well as all unknown heirs and devisees. We've served the ones that we knew of personally. We also served the unknowns as well as the out-of-state defendants by publication. 30 days has passed since the fourth publication in the newspaper, and we are asking the court to enter judgment by default.
All right, your motion for judgment by default is granted since there was no opposition filed.
Thank you, Your Honor.
Thank
I have
you.
a proposed order, which, yeah.
Thank you. Signed your order, Mr. Region.
Thank you, Your Honor.
Thank you.
I represent Melissa Eccles, who is the surviving spouse of James Ricky Eccles. We filed a motion just to deem the assets distributed as has been indicated on the inventory that we filed, or alternatively, that the property previously received by the surviving son, who is Miss Jackson Smith's client, be returned to the estate and there be a sale of all property on the inventory and the proceeds deposited with the court for determination of how they need to be distributed. That's kind of based upon the fact that the inventory was filed more than 10 months ago and it's personal property, and Ms. Eccles, quite frankly, just wants to stay closed and not have this to be a continuing issue.
Ms. Smith?
Yes, sir, Your Honor. I emailed Mr. Odell back in March and asked for a clarified version of the inventory because the inventory that was filed with the court along with his application for letters of administration, was notated in some areas which were illegible. It had already been typed, and I asked for a Word document so that I could go over it with my client. I never received a response to that email. And I received Mr. Odell's motion set for today. I let him know that I was not available today. In fact, right now, I'm supposed to be in a doctor's office in Nashville, Tennessee. And also reminded him that I had requested a Word document that clarified what was in the inventory. He advised me that I did not need a copy of the inventory, that one had been filed with the court. Your Honor, like I said, it is notated. Not only is it notated in handwriting, but it is notated in handwriting that is difficult to read. Some of it is scratched out. It is also our position, Your Honor, that some of the personal property that is currently in the possession of the administrator does belong to Mr. Eccles, my client. My goal, again, was to go through the inventory with my client, have him identify which items of personal property he believed to be his, and then to discuss those items with Mr. Odell. I would also point out, Your Honor, that there has been a significant delay in this case. When I lost my assistant, I associated my father on this case, and he had the case upon his decease. And it took a little while for the executrix to locate the file, provide it to me so that we could begin the process. It's not at all our desire to delay this process. My client is pretty clear on what personal items he believes to be his, but I saw no point in going through an inventory that I was not sure was complete or that I completely understood to be able to explain to my client.
Let me interrupt you and just say, the court file contains an inventory that is not notated on at all. It's very clear.
Well, I can show you my copy, Judge.
No, I'm just saying though, if you need to get a copy of this, if no other reason, the clerk can make you a copy today. And when you leave here, unless you need to head out as quickly as you can to get to the doctor, but you can have the clerk mail you an unnotated copy. But obviously, you would have the right to have that copy. It sounds like to me this is premature to close the estate. It's also premature to order the return of property. I'm going to allow Ms. Smith to have an opportunity to have a clear copy of the inventory, and you can obtain that from the clerk if you choose to today. And then from that point forward, I'll allow you to try to resolve the issue, and if not, you can set your motions back on the docket.
It's in the court file, was served on Ms. Jackson Smith on August 2nd, 2023.
Well, doesn't matter. We're going to give her.
I'm looking at it, Judge. I mean, I didn't notate
We can
it.
give you a legible copy today, and that solves the problem. So if you'll see the clerk, she'll give you a copy of that, and you'll have the clerk run a copy of the inventory. Your deputy clerk run a copy of the inventory, please.
Thank you, Your Honor. That
Right.
concludes my business.
Yes, ma'am.
You still got the bad pad?
Yes. I'm sorry. Yours isn't really sharp.
That's where the pad goes. That's a bad pad.
Doing the best I can.
Man, I'm feeling sorry for it.
But give it another chance.
What are we doing about getting the other stuff going? We had trouble with it all day yesterday.
Yeah, and this is a separate issue from what was going on yesterday.
A separate issue?
This has to do with your pad specifically. It's just old and tired and it needs a new
You
battery.
can't help but blame Sonny Eckert.
Mhm.
Most people do.
I'm at the house. All right. Shedrick Matthews, sir. You're here with Don Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about November 17th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on EMS personnel. Do you understand what you're charged with, sir? If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case. You would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $1,000. If you do well, it gets shortened to 1/3, 3 1/3. If I follow this agreement, you have no right of appeal. Do you understand? Also, this keeps your record clear as long as you do well. That's what you want, right?
Yes, sir. Does it have further identification?
What do you say?
Deferred adjudication.
Yeah.
Yes.
I just said deferred is deferred, and you're saying it wrong. It's not deferred unadjudicated. It's deferred adjudication or unadjudicated, which means you would not be found guilty so long as you follow the terms and conditions of probation. It's only been around for about 25 years or so, but in the old days, to get probation, you had to be convicted, then you were sentenced, and then your conviction was postponed. You didn't go to prison so long as you followed the terms, but you were convicted. This keeps your record clear as long as you do well. You get a second chance. You're gonna make the most of it?
Yes, sir.
Good. If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked here as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into
No objection.
without objection admitted. This states that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with in the indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. This states, and I find beyond a reasonable doubt, true and correct. Was that so?
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report,
Yes, it
please.
is.
Anything else to add? I'm going to follow this agreement and defer any finding of guilt as those findings have been made here in State's Exhibit number 1. Even though there's enough evidence to find you guilty, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You shall be fined $1,000. There will be a terms and conditions of probation, which I'm about to sign here, which are normal and customary for this type of offense. Make sure you follow this.
Yes, sir.
If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years. And it would be all my discretion. Do you understand?
Yes, sir.
Also, there's something here. In addition, one of the things, and this is helpful, maybe anybody can use this, is called, you will complete an anger management program. It helps you in terms of when you lose composure, how to handle yourself to make responsible decisions so that you don't fly off the handle and then end up in court.
I'm at the Unity LSU already.
Oh, good. Good. Yeah, I'm familiar with them and I'm on the board. Yeah, but go see the probation office and do well. Okay, sir? Thank you. Well, this thing keeps going in and out, you know, it'll come up and then this disappears. 24CR 2313 James Ann Jail. There's a motion to dismiss in that case. Is there a plea in that or is it just a dismissal? Okay. Restitution has been paid on that. Very good. This case is dismissed if Mr. Angel is here. That's you? Just dismissed it. Does he need to pick up anything or he can go? All right, hasta luego. Go do good things. That's a word to the wise for everybody. It's when there's a loss and a defendant is responsible for a loss restitution, you pay restitution back, you get rewarded by me. As long as you can do it timely, because it doesn't do any good if it takes you 100 years. That doesn't help the victim. But paying the loss back fixes financially to a large degree that helps defendants too in resolving their cases less seriously than it would be otherwise. Isaiah Murchison, 25 CR 428. What are we doing on this? Why?
It's a case I discussed with you.
And Your Honor, I advise Mr. Dusler, the defendant's brother is also in jail for murder, and this tampering arises out of that murder. The defendant was on a jail call on April 17th while on bond, and he's on three-way call with his brother who's in jail, as well as his sister, Amaya Moore. And he's asking his sister for
Who's he?
the defendant. He's asking his sister for some weed, money for some weed. We would just ask for a drug patch. We would ask for that he be tested today, as well as when he was in jail, he stated that
the defendant?
Yes, Your Honor. He stated that he would kill an individual by the name of Peanut if he doesn't bond him out. While he was on the phone with his sister and Maya Moore, he also stated that he would cut off his ankle monitor if you put him on home confinement. I don't believe he's on home confinement, but I would request that he be on there, and I believe he does have a GPS monitor.
Do you?
Yes, sir.
Where is it on your ankle?
I'm all right.
Well, what's he talking about? I mean, we're listening in to phone calls. It's what foolish person when you call, it states, I believe it warns you could be recorded, and we do. All of them. How foolish can you be by saying things like that are going to get you in trouble now, in worse trouble? You're looking at up to 10 years in prison for this. And all of that you're talking about, all of that can come in at the trial. That can be admitted. You think a jury's going to find that amusing? Yeah, they wouldn't take a minute to find you guilty. Well, that's what you backed yourself into by foolish behavior. You're not the only one, but that's what gets you into jail or prison, acting foolish. All right. What's his bond right now? You're not walking out of here from what I've just heard. Your bond's gonna get raised. You're gonna get tested. You're going to jail. Then y'all can celebrate together if that's what you're gonna do with whoever it is. But that's what your choices have gotten you to.
$25,000.
Yeah, that's not enough for that kind of behavior. Have a seat. Deal with you later. All right, next is Brandon Foray. He just went to the restroom. You can sit down, thank you.
He is here. I've spoken to him.
You heard him yell out and scream. It doesn't matter when you're a psychopath. After he settled, everything's That's what I do. I was trying to catch them. It's funny, he's trying to talk to a small jury. I can't see it. That's why he's right there and get him out. Just let you know, yeah, shoot. No, we read that. That's right. Where's it?
What are we gonna do on this? Is that him?
Yes, that's it.
Come on up. What are we doing on this?
It's my first time meeting him, Judge. I have a formal discovery that I'm still waiting on my tape request to be fulfilled.
It's what we do here. This is committed to trying to help dispose of these other places as possible. Because this is a back and forth. I don't like it, but help us all. This is a working order.
First time meeting
How much time? You guys, 4 weeks, get a resetting, so 4 weeks. Right? Edgar Hernandez.
Thank you.
Edgar Hernandez is called next. In cause number 25 CR 188, there is no answer in the courtroom. I asked the bailiffs to call into the hall for Edgar Hernandez. What's his bond?
$1,000 cash bond. It's only that it's his last name.
No response to that name being called in the hall. No response to the name called here in the courtroom. Defendant has failed to appear. Warrant shall be issued for his arrest. His $5,000 bond is revoked. It is now doubled to $10,000. Plus, he must have a GPS device as a condition of bond, so we know where he is when he's not in court when he's supposed to be. Escar Herrera.
He is here and so is Erica Bird.
Edgar Herrera.
What?
25 CR 122 is called Edgar Herrera. He doesn't speak English.
No, sir.
And please tell us your name for the record.
Erica Bird.
And Ms. Burge, I understand you're going to translate today. You are fluent in English and Spanish.
Right.
Have you been a translator before in court cases?
Yes, Judge.
Okay. And raise your right hand. Do you solemnly swear or affirm that you will truly and accurately translate from Spanish to English, English to Spanish during this hearing, which is Mr. Herrera's language? He speaks Spanish, and make sure that the translations are done correct so that we can have for the record the English translations and that it is clear and accurate. Will you do that? So help you God.
Yes, sir.
Lower your hand. And you are charged with the 3rd-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. Serious. Do you understand? Ms. Minaldi is your attorney. Very good lawyer. Listen to her. She gives good advice. What are we going to do then?
Judge, we were actually here for a designation today. Last time he expressed that he was going to hire an attorney. He is now expressing that he is unable to do so since he lost.
Are you able to hire a lawyer?
Not right now. I lost my brother this week. They called me for
What-
the job.
What were you doing?
This time I see him on video. Work in the refinery.
How much were you making an hour?
Estaba a la hora. 22.
22. That's $40,000 month plus. That's a lot of money. Are you a citizen of the United States? Are you a citizen of the United States?
Yes.
You don't speak English?
No habla inglés. No.
You have to be able to speak some English to be a citizen, to pass the citizenship test. How did you do that?
I was born here in Baytown.
Okay, but, okay, you were born here. You don't know English? Surely you have to be able to speak it in the refinery. At the refinery, for safety reasons, you have to be able to speak English in an emergency, correct?
Yes.
How long have you been living in the United States? You were born here.
So when I was small, they brought me back to Mexico.
Okay. Well, it comes in handy in America to speak English. Okay. Oh. What do you mean? Yeah, these things are always. There looks like an affidavit of indigence that was prepared somewhat. It's signed.
We did one last time, but we didn't have a translator available, so he wasn't able to fully fill it out. I have given him a new one today so that he can really fill it out. And Miss Burge has helped him with that.
All right. What do you want to do next?
I can have a forward reset on him to make sure that he can review his discovery and he can.
Okay, what's the offer on this one? This one now.
Probation officer, judge.
That sounds promising. The bird.
Yes, sir.
Move on. Move on. Let's move forward. We're gonna reset this for 4 weeks. Listen to your attorney. She's very smart lady. Do you have that? Hold on, everybody. Settle down. Do you have the indigence affidavit done? Okay, make sure that's done. Thank you. Get a resetting. Ryan McGowan. Come on up. 25 CR 333.
Yeah, I think they're actually.
What is that? Indigent? Are you filling it out? Is it done?
Yes, sir.
Let me see it.
He has not been sworn to it. I want to see that.
Well, I'll swear. You solemnly swear or affirm the contents of this affidavit of indigence that we prepared is true and accurate, so help you God.
Yes, sir.
Over your seat.
Great.
Take care. The court's going to declare you indigent, and that'll be filed, made a part of the record. What are we going to do?
Need a full reset, Judge. I'm still waiting on the tape request.
You got it?
Thank you, Judge.
Reset 4 weeks.
Yes.
Dewan Walter.
Dewan
Walter.
Yes. This one's been lingering for a while.
22-40934. Oh, God bless. Yes. What are we doing? It's a state jail felony. What are we doing on this?
I have an offer, but I don't have any videos. I haven't been able to relate to them because this is my first.
What's taking so long on this? It's 3 years, going on 3 years.
I showed him at an initial appearance back in February of 23.
What is your address right now?
My address, 1464 County Road.
That's where that's the problem out there. I have you at 3044 Nova. Yeah.
And Judge, at one point, he did forfeit a bond, so.
Well, that didn't help you, did it? That cost you some money?
Yes, sir.
What's your address?
1464.
Hold on. 14 what?
1464.
Okay.
County Road, 5102. Cleveland, Texas. 77327.
Zip again, 773. With that corrected on the face of the indictment. What are you asking for us?
I still need to get videos related to the case.
Could 4 weeks be enough?
Yes.
For everything? Thank you.
Thank you.
Good deal. Hi, Cooley. John West.
Oh, and only for West Cities if you like this one.
You're Ty Cooley. Have you talked to your attorney?
I'm sorry.
He's gonna be here, he's in another court. He's gonna be here shortly, okay? Thank you. Gotcha. Sterling Booker.
Hey, Jeff, good morning.
Okay.
Jeff.
Judge,
Yeah, Sterling Booker. I need the announcements. Yeah, 24 CR 23-2, Sterling Booker. That's you?
I'm sorry.
Mm,
Right. Yes, I spent about 2 hours just looking at my office yesterday, just watching videos. I think when the state get a chance to look at videos in this case, that I'm probably dismissed this case. And we might look at some of the police officers in this case, particularly Bozeman and his actions. My client was charged with assault on a police officer, particularly throwing elbows. I watched the video from the camera, that didn't exist. And when you look at the behavior of some of these officers, and I got the video, Judge, we can watch it with the prosecutor. I mean, it is not good. I mean,
all right, what do you want to do today? I mean,
it's
it's not time for argument.
Well, no, I wouldn't. I mean, it was just so bad when he said he didn't care that she was pregnant. When they let her know that she was pregnant, I don't even care that you're pregnant. I mean, Bozeman was that bad. But what I want to do,
But nonetheless, words aren't enough to cause an assault. That's not a defense. Words are not a defense to an assault. And it says by striking about the head and body with her hands. I mean, did you see that happen?
I watched, yes, what I did.
Okay.
Yes, I watched the angle from the car looking at them, and you don't see strikes to the head or anything. And when the state get a chance to look at this video, I think that they're gonna come to the same conclusion. And it might end up being a dismissal, Judge.
Okay, but right
And I
now
got
it's an announcement. What do you want to do?
What I would ask you to do is to give the state time to look at all angles of the video, and I can show the one I'm particularly talking about. Put it on another announcement, and if Miss Sarah agrees with me, I think she'll dismiss this case. But I can do it right now.
30 days, Your Honor.
Okay, 4 weeks.
That'll work.
Roisha Diaz.
That case is here, Judge, and I talked to Mr. Sonny, that's gonna be dismissed today.
We sent her to the bank to get the restitution.
Okay, did you get it?
It's coming up right now.
Okay, when it's done, send it to me. We'll dismiss it.
That'll be
Okay,
dismissed today.
TBD.
Thank you.
You're right. Brian Smith, Langston, we're still on.
Oh, I'm sorry.
Yeah, Brian Smith.
I called his name several times, no one answered.
24 CR 840 is calling some cases.
I think he has a warrant though. That's probably right.
Brian Smith, there is no answer in the courtroom. I asked the bailiff to call into the hall for Brian Jeffrey Smith.
Yeah, Judge, I think he has a warrant, so.
Well, if he's here, that'll take care of that.
I called.
What's his bond, please, right now?
Oh, he's, Judge, I got a call yesterday from a jailer in Arkansas. He's incarcerated in Arkansas right now.
Okay, for what? Do we know?
It was, I think it was a couple of misdemeanor offenses, including a terroristic threat.
When were those, do you know anything about when those were committed?
No, but I think they would have,
Bond?
right, I believe he would have been on your bond, when, at the time, right. Either way, he's gonna fail to appear today, so
What's his bond amount?
and I think he has a warrant out of our court anyway right now. Okay, that's what it is. So he might as well accrue time for, and then you can deal with the bond issue and get him. Okay.
What is is there a bond attached to it?
It's an AFRS warrant.
Okay, so there's no bond on it. Yeah, okay. I don't think we need to do anything.
No,
else.
sir.
Okay. Oh,
Wait,
sorry.
it's back in Target City.
All right, Rodney Broussard is next. Dustin? Yeah, I'm on. Where's Rodney Broussard? Is Mr. Broussard around?
He's in custody.
Yes.
Anybody send Dustin?
He's got it,
Richard Cook. Richard Daniel Cook, is he in custody too? Richard Cook? There's no answer.
But.
He's not in. Richard Cook. Richard Cook, 22-39655, no answer in the courtroom. I asked the bailiff to call into the hall for Richard Cook. What's his bond? Thank you.
There is no response, Your Honor.
There's no response to that name called in the courtroom. No response to the name called into the hall. Defendant has failed to appear. Warrant shall be issued for his arrest.
$15,000.
Bond is revoked. 15,000 is now $30,000 plus he must have a GPS device. Rodney Broussard. He's in
He's in
custody.
custody. Can we pass on that?
No. What are we gonna do?
Well, I need to go back there and talk to him. I hadn't had a chance to talk to him. Just to make sure we're on the same page. But that's a bond issue, so.
No, we got a motion to revoke probation announcement, right? I mean, we gotta dispose of cases.
This is the probation.
And the probation officer is here. The next,
I think the state's recommendation is after talking to the probation officer.
yeah,
What we'd like to do is he's been in jail for 80 days. He had been in a different parish when he wasn't reporting. After he got out of jail, he still did not report. So what we would like to do is do a 60-day jail sanction. He's already served it and then have him do safe P as part of probation.
what's the other two cases all about? Oh, these are all MPRP?
TRPs, they're all together.
That's correct.
Why don't y'all see if that's the way to do it? That helps him and we can move these three, get them moved. Okay. DeMarcus Jones, while we're here.
Marcus Jones, President, Courtroom Judge.
Mr. Jones, come on out.
Have not had an
Marcus
opportunity,
Jones, please.
not had an opportunity to review all of the discoveries that were asked for other names. It's a fairly good case.
Oh, sorry. Here, Bruce.
Okay, on Keith Road, do I need to defend it out here, Bruce?
Yes, sir.
Do we need to defend it? There's,
Probably.
Judge, I don't think he's here. If it's a recommitment.
It's a recommitment,
Yeah, he's probably still in the
the
hospital.
paperwork shows, Judge, that they declared him mentally competent. And there's an order to file.
stand on.
Let me look, this docket shows him on, has to be that.
All right, I've got.
This is the order. I don't know if you have that.
What's the date on it?
That was filed, April 28th. It's an agreed order.
Nope, I don't. Hold on. Hold on.
It already has a signature on.
Where are you?
There was a problem here on this.
Let me go get Kim, Judge, so.
Yeah, there's nothing in there like that.
Yeah, I don't know anything about that file.
Stand by. Look at it, but I don't have this in the files for some reason. And it's already been stamped. See, I think I automatically, this was automatically signed by me, entered April 28th of 2025 for an additional 60 days. So it goes with 60 days from this date. So really, June 28th, 27 is when we need to be back on this.
That'll be fine.
Kim's gonna come.
I'm sure you can see some more pictures.
But I don't have, Mr. Smith gave this to me. That's nothing like this is in the file. That is, I've gotten, that signed, but there's, you see it stamped, received on that date. He's set for a hearing today, but I don't need a hearing. I signed that. I need a hearing in June when the 60 days are up.
Yes.
All right, that's when we need to reset it.
And
June
I'm sorry.
27th.
I put everything in the computer, but yeah.
Yeah, there's nothing in here. All that, he was talking about that. That's his. I don't have that. I need a copy from my
I will.
file.
I'll get it for you.
What's day? What's June 26th or June 27th, day of the week, please?
June 26th is a Thursday, June 27th is a Friday.
What's the date on that? Right there, that's
4/28.
I'm sorry, the date is, I'm dating it April 28th. Okay, I need it on the 26th. June 26th, that was only for 60 days, so. Yeah.
Make sure it's in.
Okay, reset for June 26th.
Oh, that's your copy. I'm good.
Thanks, Bruce.
You're trying to start.
I think.
Okay, Crystal Vaughn
Yeah, I'm working on the paperwork.
and Dustin Jones.
Just trying to ready for a plea.
All right, let's, Dustin Jones, please.
Yeah, we haven't called her yet, though. But she used. I don't know, we haven't called her. No, she's online. And Judge, I need Wright and Scott to come up and sign a resetting.
White and Scott, where are you? Come on up.
And who's the lead, Bruce? Dustin Jones, you said?
Dustin Jones,
Okay, I'll just, the fingerprint.
you need to be fingerprinted. We're gonna do a plea here.
Yes, sir.
Here, go in front of that nice lady. Thank you.
All right.
First. Mr. Jones. Mr. Jones, please raise your right hand. Do you swear or affirm to the truth and nothing but the truth yourself you got? Please say it. You can prove it. Place it flat right there. You can open one more time. Let's do it myself. Over the check.
24C01 326 is called the state of versus Jones. Mr. Smith is your attorney, correct? Where'd he go? There he is. You are here with Mr. Smith, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes,
Need
sir.
a prosecutor, whoever.
I'm coming up, Jed. I'm just getting.
In summary, this indictment alleges that on or about April 28th, 2024, in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand, sir, what you were charged with here?
Yes, sir.
If convicted, you face a term of life in prison, a term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty. Whatever sentence shall not exceed a cap of 8 years in prison. So we are looking at no less than 5 or more than 8 years confinement in prison, or you can be placed on deferred or unadjudicated probation. I think those are the two options. Because a firearm was used, so regular probation is not an option.
That's correct, Judge.
But deferred or unadjudicated probation is, and then straight flat time not to exceed 8 years, 5 to 8 years as the two options. I'm going to order a pre-sentence report. We'll come back and then the court, everybody will place into evidence what they feel like I need to hear, and then the court will make its decision. If I follow this agreement, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Is everything true and correct?
Yes.
State's Exhibit 1 tendered into evidence
Okay.
without objection admitted. The state you were mentally competent to enter your guilty plea, and it's being freely and voluntarily made. You know what you've been charged with. The indictment's been read for your use ready. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and cross-examination of witnesses. You're totally satisfied with the representation by your attorney. All of this is true at state, so help you God. State's Exhibit 1, part of the record for all purposes. I'm going to order a pre-sentence report. We will return back on
July 7th.
July 7th, 2025. Everybody can add additional information and the court will make its decision. Thank you.
What is that?
And then Crystal, you're working on Crystal?
Yes, Your Honor. They had trouble with the tap.
And yeah, that's systemic, I'm afraid now. Yes, Don.
Yes.
Come on up.
Thank you very much.
No, I won't.
It was an add-on and it was shown there.
It's not even shown.
No, it was not. We did it.
What are we doing?
He tested positive yesterday and you wanted him brought back today. Basically, he's asking for some more time, but once he gets out of jail to our attorney, so we 4 or 5 week reset.
I need his
Fine, bearing, but I know you're gonna get a test daily until he tests positive.
They test negative.
Negative.
The object is not to use drugs and stay in jail. It's to stop using drugs. You tested positive yesterday with THC. Did you want to say something?
Yes, sir.
Go ahead.
I had just got arrested a month ago, so even if I had stopped smoking weed then, I would have not been clean.
yesterday when I came here. I smoke copious amounts of marijuana. So if I smoke 2 ounces, it's not gonna come out of my system in 30 days, you know? So I came here only because it wasn't that I'm not trying to get clean. I am trying to get clean. I'm trying to do the right thing. So it's not me being in jail isn't gonna help me do the right thing, but I can guarantee that next time I do come to court, I will be clean. I will not be dirty. I will be clean. I will be on top of my game. Everything you need me to have getting done, I get it done.
How old are you?
I'm 29, sir.
You think it's about time you grew up and matured and became an adult, or are you gonna stay childish the rest of your life?
Grow up, so I'm trying to get
Really?
together.
How long have you been using drugs?
I've probably been smoking weed. I don't use drugs, I only smoke weed, so. But since I was probably 14 years old.
14?
Yes,
And you're
sir.
how old right now? 90, you were born in 95, so you're 30 years old?
29.
You're going on 30 in
Yes, sir.
October.
Yes, sir.
No. Okay, well, how many, each time you use drugs illegally, it's a crime. It's a foolish decision and it's a wrong decision. How many of those wrong decisions do you think you've made?
I made a lot, sir.
Thousands?
You did a lot, sir. I can agree to that.
Yeah, okay. Well, it's never too late to mature,
Yes, sir.
but talking about it doesn't do it.
That's what I'm trying.
You got to
I'm trying to show
walk the walk. You know what I mean?
Yes, sir.
Everybody says, just let me out of the mouse trap. I'll never eat cheese again. But there are a lot of cheese eaters,
Yes, sir.
like a mouse. Just let me out. I'll never eat cheese again. But that's the nature of their beast, of the beast. They eat cheese.
Right.
Similarly, people get attached to drug usage and they will say and do anything to get out of confinement.
No, that's not right here, sir. I have school that I'm.
So you can say no all day long. Don't make me sound foolish. You and I know.
Trying to go.
Hold on. How long have you been using drugs?
Since I was 14.
Half of your life.
Correct.
You don't think that's a consistent wrong choice lifestyle?
Yes, sir.
Okay. Well, anyway. What was your bond? We revoked it. Yes.
It was, I believe, 15,000.
Yes, sir.
Well, he's not going anywhere testing positive. We're gonna have to see what's in his
If you would
system.
reinstate his original bond, as soon as he tested.
I don't think so.
Okay.
No, I mean, it's gonna be doubled and they'll have to have a drug, like all of them, but you're gonna sit over there and we'll test you and see if you're testing positive or not, but until you test negative, I'm not letting you amble out of here. You understand? Sit over there.
You understand.
Thanks.
I just have school I'm trying to attend.
You can talk about it all day long. You gotta do it, sir. What else?
It's all I was gonna reset him. He'll still test positive today.
Okay.
Reset him for us. Announcement, maybe his family can hire an attorney.
Okay. That's Mr. Murchison.
We done.
He's gonna get tested, whatever. John, John West, where's John?
Never, it's gonna be late today.
Hey, David.
Yes, sir.
We got some stuff. I hope you can move some things here. I've got Arthur Gilder.
Judge, that's the case, but he has a second felony
Yeah.
that I was aware of, but I had not spoken to the law enforcement officer, and I need to do that, so I have trouble.
But
2 weeks, good? All right. Where's Mr. Gilder? Right here?
we do.
2 weeks reset, please. We need to, we need to move those, we need to move that one way or the other in for his life, so we can see what direction you go in. Just reset 2 weeks. Aretha Jackson. That's a.
Judge, that's a case where she would like to ask her case to be set for trial with another attorney, I believe, someone that might help her with the case more so than I've been able to.
Well, I mean, you're a competent lawyer. I mean, you're gonna try cases. Are you able to hire somebody?
No, I'm sorry.
All right. Well, Mr. Grove is a competent attorney. Yeah, he was a great trial lawyer before I was a lawyer. So,
I believe she thinks her case may be able to be moved quicker if she had someone who did.
we're gonna set it for trial, David, and you're gonna be the lawyer on it.
Yes, sir.
Y'all can move it.
Trial,
Otherwise,
yeah.
let me know. Was there an offer?
Yes, sir.
What was it?
The offer was deferred adjudication.
Okay, yeah, she understands that is not a conviction and that it can be shortened to 1/3, whatever the amount of time is uh, on the deferred, and that keeps her record clean. You understand all those things? All right, we'll set it for trial. Okay, that's your choice. If you're convicted though, if you're convicted at trial, that's a forever conviction. It's not like deferred where you're clear.
Yeah.
You just need to know there's a big difference between a jury cannot give a deferred probation, only I can. And that's no longer available for you. Keeler Maldonado. What are you going to do on Mr. Maldonado? Here. Come on up. What are we going to do on this one, David?
On Mr. Maldonado requests this case be set for trial.
Well, what was the offer on this one too? Was this a deferred?
No, sir, I don't believe that was Mr. Maldonado. This was a PDC time, let's just say, to find the file.
I need, I think I got it. Hold on. No, I don't.
Here, I got it.
Are you working somewhere?
I'm working with my cousin right now, landscaping. I'll be going with him 2 to 3.
Well, how much do you make?
100 per yard. Whenever I go, I got his car.
What's his bond on this case?
$30,000.
Who posted your bond? You did? Well, yeah, somebody posted a $30,000 bond to get you out of jail. Who did that?
Sure.
You don't even know? It wasn't you though, right? Why not? You're not an adult taking care of your problems? Somebody else is? You're in a mess. You're looking at life imprisonment. Do you know that? Do you understand and appreciate that? Do you? You're looking at life imprisonment. You can't get deferred or unadjudicated probation in front of a jury. In fact, whatever sentence you get for an aggravated robbery, it has to, 50% of it has to be served in prison. So if you get 50 years, you got to serve 25 years at least before you're paroled. You understand how serious this is? Do you? But you don't even know who bailed you out of jail?
Who bailed me out?
Your cousin. Who was your cousin?
Anthony. I think that's his name. They call him. I think it was Anthony.
Okay, what's his last name? You don't even know the name of the person who is a relative of yours who bailed you out? What kind of family is this? Y'all don't even know each other's name?
Sure, I just don't know his last name.
Have a seat over there. Okay. We'll get back to him in a little bit. Okay, David, on Venetia Mims.
That'll be a plea, Judge. I don't ever signed up yet.
Okay. Miss Mims, he's got to do some paperwork. If you can get that done as soon as possible. Thank you. Anthony Owens. Just stand by. She's going to do some paperwork and work with you here. Thank you, ma'am. Anthony Owens, what are we going to do on Anthony Owens?
Anthony Owens, wants this case set trial.
Where's Anthony Owens? That's you? All right, you have a seat over there too. Right over there. Jacali Palmer.
Judge, if I could, speak to the prosecutor, District Court, about that. He'd like to withhold that for a little while.
And Dalen Parkerson.
Dalen, Parkerson, Judge, I'd like to have a reset on that. There's some additional investigation.
How much time do you need? 4 weeks?
4 weeks.
That's all? Okay. That's reset. Darius Smith. Darius, get him a sentence. Darius Smith.
Darius Smith would also like his case, set for trial, I believe.
Who goes to trial for unlawful possession of a firearm by a felon?
I'm not trying to go to trial, sir. I just know Mr. Rose is a busy man, and I was just trying to get the case resolved.
Oh, you were.
Well,
He says he.
I'm not offering information on parties.
What's he offering? What's he offering?
The offer on it